You ready? All right, I call cause number 10,861, the case style of the state of Texas versus Patrick Miller. The record will reflect the state's counsel is present. Mr. Miller, the defendant in this case, is also present. Mr. Miller, I am looking at the document entitled Acknowledgement of Arraignment. I'm going to attempt to show it to you on the camera, in particular, your signature. Can you see that signature?
Yes.
Is that your signature?
Yes, it is.
Do you have any questions about that acknowledgement of arraignment form?
No, sir, I don't.
All right, it is accepted. And then I've also examined your affidavit of indigence and request for appointment of attorney. I find that you are eligible for the appointment of an attorney. The next attorney that is on our rotation list, or the attorney that comes up for your appointment, is an attorney by the name of Jeannie Fuller. Mrs. Fuller practices criminal law in this court and in other courts around this region. Her primary office is in Colorado City. She also has an office in Sweetwater. We will provide her with a copy of this information on the affidavit of indigence because it has your contact information. Is that information correct?
Yes.
She will mail you she will send you a letter advising you that she is aware she has been appointed, and then you will set up times with her office to begin the representation so she can begin assisting you. Today, because you have a condition of bond, today you will also report across the street from the courthouse to the probation department, the adult probation department. You will ask to speak to Mr. Oliver. You can see Mr. Oliver on the screen with us. And you will then you will sign up for bond supervision. You will be required to report for bond supervision each month, sometime between the 15th and 20th days of each month. You will pay a bond supervision fee of $50 per month. And then you will also pay $50 per month, which will be used to reimburse the county for expenses that you have incurred, or that the county incurs in your behalf to pay an attorney. Do you know where the probation office is here in Snyder?
No, is it far from this building?
No, sir, it's directly across the street.
Oh, okay, so I'm kind of there.
You're kind of there.
Oh, that'll be good.
It's in the middle of the block on the west side of the square. Just go out the west side of the courthouse, and essentially the west, you are sitting in the the jury room, and you're basically facing east. If you walk out the door behind you, you will be facing west.
Okay.
So you just go down the stairs and you go out that way, and go directly across the street. That's the probation office, and you'll ask to see Mr. Oliver, and they will sign you up and give you the rules, and you'll report each month while your case is pending here in our court. Do you have any questions?
No, sir, I don't.
Thank you, sir. You may be excused. Yes.
One question though.
Yes, sir.
When do I find out when, like, pretrial trial or whatever?
There will be another pretrial 1 month from now. Today
okay.
is the 4th. Your attorney will get a notice, and your bondsman will get a notice of that setting. But generally speaking, it will be on Thursday, March 4,
Mhm.
2021, and it will be at 1:30, although we will schedule it sometime during the day, depending upon your attorney's schedule. And so another reason it's important for you to be in communication with your attorney.
Okay, good enough.
Right.
Thank you, sir.
Thank you, sir. You may be excused. All right, he's coming in.
You guys.
Thank you, sir. We're fine. Mr. Dreger, you may remove your face covering while you're in that room. I call cause number 10,858, the case style, the state of Texas versus Jacob Fair Dreger. The record will reflect the state's attorney is present and Mr. Dreger is present. Mr. Dreger, I'm just going to follow up on the matters that I talked to you about earlier this morning. The first thing I want to talk to you about is the acknowledgement of arraignment form. I'm going to try to show it to you on the camera or on your laptop. Oops, sorry, I did that wrong. Can you see that form?
Yes, sir. I'm having trouble reading it. So.
Can you see the signature?
Yes, sir.
Is that your signature, Mr. Dreger? Is that your signature?
Yes, sir.
All right, sir. Did you have any questions about that form?
Oh, sir.
Okay. Then I would also tell you that I have looked at your affidavit of indigence and request for appointment of attorney. I find that you are eligible for the appointment of an attorney. And we use a rotation system for appointment of attorneys. The next attorney on the rotation is a lawyer by the name of Morgan Brooks. Ms. Brooks is an attorney who handles criminal law cases in this court as well as other courts in this region. Her primary office is in Colorado City. There is also an office for her in Sweetwater. We will notify her that she has been appointed to represent you, and we will send a copy of the letters to you so that you will know her name and contact address. I would recommend to you that you get in touch with her on your own. She will send you a letter in the next few days telling you she has been advised that she has been appointed to represent you. And then you will want to set up an appointment to visit with her as your schedule and her schedule will allow, because we will reschedule your case for 1 month from today on March 4 in the afternoon, unless you and your attorney schedule a different date. Your attorney will take care of that. You will not receive a notice from our court about your March 4 hearing, but your bondsman will receive the notice and your attorney will receive the notice. Do you have any questions, sir?
No, sir.
Then one last thing. There is a condition of your bond that's attached to your bond that requires you to report for bond supervision. To report for bond supervision, you will go today. As soon as you get through with this hearing in the next 2 or 3 minutes, you will go across the street from the courthouse to the adult probation office. And you will ask to speak to Mr. Oliver with the probation department. Mr. Oliver is appearing with us in this hearing. You can see him on the screen. Do you see Mr. Oliver?
Yes, sir.
All right, you'll ask to speak to Mr. Oliver, and he will register you for the bond supervision program. You will report for bond supervision once a month, sometime between the 15th and the 20th days of each month. He will give you a schedule for that, and then that will continue each month until your case is completely taken care of. You will pay a $50 per month bond supervision fee, and you will pay a $50 per month reimbursement fee, which will be used to reimburse the county for expenses it spends in your behalf, namely in the payment of attorney's fees. All right, that's a lot of information. Do you know where the probation office is?
Yes, sir, I do.
Okay, then if you will go directly over there, and they will give you they will register you for bond supervision and tell you when your next time to show up for bond supervision is. Do you have any other questions?
No, sir.
All right, sir. That concludes our arraignment today. You may be excused to go across to the bond supervision office.
Thank you, sir. Thank you, guys.
Thank you.
Have a great day.
That's one way to get rid of the judge.
All right. Pardon the pause. Let me get the sheriff's office in, or the law enforcement center laptop, and see if we can't get Mr. Keith's pretrials taken care of. Ms. Phipps, you might tell them that I'm trying to admit them in and need their audio and video.
Judge, I'm going to darken my camera as I do these bond supervision appointments, but I'll be listening if you have any questions of me.
Okay, very good. Thank you. Go ahead and mute yourself as well so you can do that.
All right.
All right, let's get started. And for purposes of pretrial, I call cause number 10,794, the case being styled the state of Texas versus Tommy Ray Hull. For the record, this hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. It's also being live streamed on the court's YouTube channel in order to comply with Texas Supreme Court orders and Office of Court Administration rules and directives that require us or suggest that we use these formats to make the public, to provide public access to the court proceedings and to provide safety measures to all the participants. With those pronouncements being made, I also announce that all parties are prohibited. All parties who might have access to this proceeding are prohibited from recording any portion of the proceeding in any manner, except for the official court reporter who is in fact recording or transcribing the proceeding just like he would do if we were in court. With those understandings, for purposes of pretrial and cause number 10,794, what says the state?
Ready, Your Honor.
and defense.
Ready, Your Honor.
And we'll note that Mr. Hall is present in the video courtroom or the virtual courtroom as well. Are there any pretrial matters we need to take up in Mr. Hall's case at this time?
Nothing from the state, Judge.
In defense?
Judge, Mr. Hull and I have an agreement to dispose of this case. Mr. Hull and I have executed the paperwork. Mr. Smith has signed it as well. I was wondering just a moment ago why you didn't have this in front of you, and it occurs to me it's because I have it in front of me. So I can bring this to you as soon as you're ready for it, but that's the status of our case, Judge. We have an agreement and we'll ask you to approve it.
Are y'all trying to do do y'all want to do this today?
Sure.
Yes, sir, if you can.
Mr. Smith?
Judge, I'm ready to do it anytime, whenever we have time.
Would y'all be available to do it at 1 o'clock? I can do it. I will do it at any time. I would stay and do it. I don't know what, we can stay and do it when we finish all of your pretrials, if that's acceptable to the state. If not, and the defense. If not, I would say we reschedule it for 1 o'clock.
I could stay and do it.
That suits me, Judge. I don't think it'll take too much time for the remaining pretrials.
All right. Okay. Then thank you, Mr. Hall. We will invite you back in as soon as we finish other pretrials of Mr. Keith's. Thank you. Yes, sir. You may step out.
Yes. Judge, do you prefer anyone next?
I was thinking we would do Billy Rodriguez.
Okay, yes, sir.
While he's getting here, I'm going to bring these papers to you, Judge.
All right.
Or to Kayla.
Kayla, would you bring me the files when he brings that to you? If you'll bring them all in to me. I didn't know Trey was up here.
He actually showed up 15.
Well, I let the time get away from me. I didn't realize. Not immediately. She didn't want to.
Let me go.
All right, our next call for pretrials, cause numbers 10,734 and 10,735. Each case being styled the state of Texas versus Billy Rodriguez. For purposes of pretrial, what says the state?
Ready, Your Honor.
And defense?
Ready, Your Honor.
All right, we note that Mr. Rodriguez is also present as we are conducting this hearing virtual by remote video teleconferencing technology. Do we have any pretrial matters to take up in these cases, Mr. Smith?
The state does not have pretrial today, Judge.
Defense?
Your Honor, because Mr. Hull's plea will result in placing Mr. Rodriguez first on the trial docket, I need to request that this case be continued at least to the March docket. I have just this morning received additional discovery in this case, which is at least as voluminous as the first round I received several months ago. And I need time to review and digest that, Your Honor.
Judge, it is the case that we discovered, or I discovered, that there was some additional discovery that had not been provided to Mr. Keith previously in this case. We've been providing discovery and supplementing discovery all along, but there was some additional that we had just discovered that I think was uploaded to the discovery portal and provided to Mr. Keith either yesterday or this morning.
Okay.
With that, I don't have an objection to his request to move this to the March docket. The state will be ready in March.
I'm confident that will excite Ms. Morris.
She could stand some excitement, I would imagine.
All right. I grant that continuance until the March docket. Is there anything else that we need to take up in Mr. Rodriguez's case while everyone is with us in this remote video teleconference hearing?
I have nothing else, Judge.
No, Your Honor, nothing else at this time.
All right, then we will be in recess in Mr. Rodriguez's case. Thank you, Mr. Rodriguez. You may be excused.
Okay. You can go. We're done. He's done.
Come on, Doug. I just have this for you.
Thank you.
Go ahead.
Sit down and take off your mask while you speak to the judge. Thank you.
Good morning. Good morning. Ask me first. Are you Mr. Koff?
Yes, sir.
All right, I call cause number 10,629 for the case styled the state of Texas versus Billy Ray Koff. This is a pretrial hearing on the motion to revoke probation filed by the state. This hearing is being conducted by remote video teleconferencing technology and is being live streamed on the court's YouTube channel. The prohibitions against recording any portion of the proceeding remain as stated. For purposes of this pretrial, what says the state?
Ready, Your Honor.
And defense?
Ready, Your Honor.
Do we have any pretrial matters to take up at this time in Mr. Koff's case?
The state does not, Your Honor.
And Judge, I'll just make you aware that an attorney from another jurisdiction, San Antonio, if memory serves, contacted me and requested my signature on an agreed order to substitute. My understanding from that attorney was that he was hired on behalf of Mr. Koff, and I'm going to assume it's by Mr. Koff's mother, but in any case, I signed it. I assume that is Mr. Koff's wish, but I'd appreciate it if he would confirm that on this occasion. But in any case, I just wanted to make you aware, Judge, that after I received that, Mr. Smith and I effectively, I ceased to spend attention on the case.
All right. Mr. Smith, have you heard anything from another attorney regarding Mr. Koff's case?
Yes, sir. I didn't speak with the attorney, but I know he called our office yesterday and inquired of, probably wanted a copy of the motion. I think we probably emailed it to him. And then the only other information I had received was I'd noted that he had filed, I think, a motion to substitute counsel and was attempting to get a court order in front of you to accomplish that.
Right. I haven't seen that court order or proposed order. Mr. Koff, are you aware of what's going on with
I
the
was
respect?
informed this morning, yes, sir. Sorry to interrupt you.
It's all right. Thank you. Is that what you wish to do?
Yes, sir.
All right. Do you understand that that's by itself is going to cause at least a small delay, but I will try to get your case back up as soon as I can find out who the attorney is.
Okay.
Is that something you understand and accept?
Yes, sir.
All right, sir. Then let's not take up any more of your time, Mr. Koff, or the other court participants, and we will reschedule you for a hearing as soon as we can identify the attorney, and I assume as soon as you have, or after you have a chance to confer with the attorney.
I was under the influence that he was on his way here today because I think he was told that I was supposed to be in front of the judge at 2:30 this afternoon. I haven't heard from anybody since.
All right, sir. I haven't heard that either. If an attorney shows up or contacts us and is willing to have even just a cursory hearing with you this afternoon, we will try to accommodate and make that happen. We do have a very packed afternoon, but we will try to accommodate you and your new attorney.
Okay.
All right. Thank you, sir. You may step out.
Thank you.
Randy?
Yes, sir.
Randy? Are you about to bring in Ms. Tondre?
I am, yes.
Say again?
Yes, Judge.
Would you hold off just a moment and let me do another one? And then
Yes, sir.
I'll do another one by Zoom, and then then I'll tell you and we'll get Ms. Tondre back on.
Yes, sir.
Okay. Let's get Mr. Hallman on here. Mr. Hallman, can you hear us? That's the problem with, nope, not yet.
Excuse me.
There we go. It's not connected. There. Looks like you have it now, Mr. Hallman. You're muted, though. You need to unmute.
Okay, there we go.
Thank you, sir.
Yeah.
I call cause number 10,845 for the case style, the state of Texas versus Skylar Halen Hallman. This is a pretrial hearing in Mr. Hallman's case. The hearing is being conducted by remote video teleconferencing technology using Zoom protocol. It's also being live streamed on the court's YouTube channel, all to comply with Texas Supreme Court orders and rules and directives from the Office of Court Administration. For purposes of pretrial, what says the state?
Ready, Your Honor.
And defense?
Ready, Your Honor.
We'll note Mr. Hallman's appearance. Mr. Hallman, where are you physically located right now?
Right now I'm in Austin, Texas.
All right, for all future court appearances, you will appear in Snyder.
Okay.
All right, sir. We'll note that on the docket sheet that you've been so instructed. For purposes of pretrial, does the state have any pretrial matters?
No, Your Honor.
And Your Honor, the defense does not have any pretrial matters.
What do we anticipate doing with this case?
Judge, I've received the discovery, video materials, written materials, and that sort of thing. And I've received an offer from the state, which I've conveyed to Mr. Hallman, but I haven't had an opportunity to show it to him. What with him being located not out here in West Texas. In any case, my expectation is there's a likelihood that this would dispose without a jury trial. So that's the best I can tell you. I believe we will not need a jury trial.
Right. This case is set on the court's jury trial docket for Monday, the 22nd, or February the 23rd. And a plea cutoff has been set for end of day, February 12th.
Okay.
Let me tell you, Mr. Keith, that I have been informed that most of the cases in front of Mr. Holman are pleading today. So you'll want to double check on the status of trial.
Yes, Your Honor. Judge,
Yes.
so the court, certainly I can check with your administrator, but I just wonder if you've got already, are you looking at a day next week when would be best?
Are you scheduled here on any other day?
Judge, I don't believe so. Not yet. But I think I'll need to be scheduled sometime soon for the sake of Miss Tondra. Are you available for the afternoon of the 12th?
Of when?
Friday, the 12th?
I am. So one of us has feedback problems. It could be the YouTube channel. But I'm available on the 12th. Yeah.
So am I.
Okay. And
Is
Judge?
1:30 available?
yes, sir.
Yes, sir.
More importantly, that question was directed to the coordinator.
Of course.
Yes.
All right, then we'll set it for 1:30 Friday afternoon, February 12th.
Okay. And Judge, if I may address Skylar just for a moment.
Okay,
Skylar, I'll give you a call sometime this afternoon or tomorrow. and I'll discuss what I saw in the material I got from the district attorney, okay?
Okay.
And then you can tell me whether you want to have a trial or something different. Okay?
Okay.
All right. Thanks for being here, but hang on until the judge tells you you can go.
Okay.
Anything further?
No, Your Honor.
No, Your Honor.
And we will be in recess in Mr. Holman's case. Thank you, Mr. Holman. I will excuse you and I'll take care of that.
Okay. Thank you, sir.
See you soon.
I think it was his phone.
Now that he's gone, I think it was his phone.
I think he was running it through his car speakers or something.
Could have been. Could have been. I thought we had corrected the issue of somebody appearing remotely. I want them in person in Scurry County when we do our pretrials.
Okay.
But no harm, no foul.
Okay, I missed that memo and I sent him the link and told him he could do it that way. And I apologize. I didn't.
No, don't worry. Don't worry. I don't think I sent that memo out. So don't worry about it. As I say, no harm, no foul. All right, that Ms. Tondre?
Yes. Hi, yes, sir.
Good afternoon, or good morning.
Good morning.
Unfortunately, it is good afternoon. All right, I call cause number 9,881, the case style, the state of Texas versus Lachelle Lynn Tondre. This hearing is to conduct a pretrial hearing on the state's motion to revoke probation. This hearing is being conducted by remote video teleconferencing technology using Zoom protocol and is also being live streamed on the court's YouTube channel to comply with Supreme Court orders and OCA rules and directives. With those announcements, the prohibition against recording this proceeding by anybody continues, except for the official court reporter, who will, of course, record it just as if we were in an in-person hearing. For purposes of the pretrial, what says the state?
Ready, Your Honor.
And defense?
Ready, Your Honor?
And do we have any pretrial matters to take up in Ms. Tondre's case, who is also present with us?
Judge, the state has nothing. My understanding is this will also be a plea on the afternoon of Friday, the 12th.
Yes, sir. That's right. I just need to get the paperwork from Mr. Smith's office, and prior to that hearing, I'll go out and see Miss Tondre and get her signed up.
All right. Then, although I'm available and will be happy to visit about anything else in this case, let's don't waste everybody's time if there is nothing else. There being nothing further, we will be in recess, and Ms. Tondre, you may be excused. We will see you next week when we will schedule your case to take care of the matters your attorney just mentioned.
Awesome. Thank you.
Thank you. Okay, you can bring Mr. Hull back in if you want to, if you would, Randy.
You have the paperwork.
I do.
Who's that, Judge?
I think we're ready for Tommy Hull now.
Okay.
Again.
You want, okay, yes, sir. Tommy.
Did you have any other case, Trey?
No, Your Honor.
Judge, I'm half a second behind. We're getting them right now.
That's fine. I appreciate it.
Judge, just before I brought the papers over to Kayla, I flipped through them again. And you got two certificates of right of appeal, one for this case and one for last month's trial. You've also got two waivers of jury trial, basically, obviously one for this case and then one for last month's trial. I noticed that the one for last month's trial, I guess it's whatever the number is, 5, Lynn's in 5. That one contains the date January 27th. which obviously, when you sign it, it'll be February 4th, 2021. In any case, I just wanted to bring that to your attention because the date indicates only the date on which you sign it. I'd be satisfied with you just correcting the date by hand, but certainly that's your call.
All right, thank you. That's what I'm looking.
I gotta go back there. I see Jeremy leaving. Jeremy.
Doesn't he?
No, he's gonna go crazy. Everybody's telling you. I'll let someone know. I'll touch him up here.
Mr. Keith, Mr. Hall, Mr. Hanshu is now on, should be on your screen. He is going to talk to Mr. Hall for just a moment in order to be able to notarize his signature on the stipulation of evidence.
Mr. Hull,
Yes, sir.
do you see this stipulation of evidence?
Yes, sir.
Did you go over this with your attorney?
Yes, sir.
Is that your signature?
Yes, sir.
Do you swear that everything in there is true?
Yes, sir.
Thank you.
Welcome.
Ready? All right, I call cause number 10,794. For the case styled, the state of Texas versus Tommy Ray Hull. For the record, this hearing is being conducted by remote video teleconferencing technology using the Zoom protocol. It is also being live streamed on the court's YouTube channel to satisfy Texas Supreme Court orders and rules and directives of the Office of Court Administration. The plea papers that have been handed to the court and the discussions just before we got on the record indicate that the defendant desires to enter a plea of guilty to the charges in this indictment and to do so pursuant to a plea agreement between defense and state. With those understandings, what says the state?
Ready, Your Honor.
And defense?
Ready, Your Honor.
Are you Tommy Ray Hall?
Yes, sir.
Mr. Hall, an indictment has been returned into this court in cause number 10,794, charging you with a third-degree felony offense of driving while intoxicated. You have the right to have someone read the indictment out loud to you here in open court. Let me also tell you that the indictment carries and contains enhancement paragraphs as well. Do you wish to have someone read the indictment and enhancement paragraphs out loud to you?
No.
Do you understand that the indictment does charge you with a third-degree felony offense of driving while intoxicated, and it contains 2 enhancement paragraphs?
Yes, sir.
To the charge of third-degree felony driving while intoxicated, how do you wish to plead? Guilty or not guilty?
Guilty.
And to the two enhancement paragraphs, how do you wish to plead? True or not true?
True.
Do you understand that you do not have to enter a plea of guilty to these charges, and you do not have to enter a plea of true to the enhancements? You have the absolute right to enter a plea of not guilty and not true to the enhancement paragraphs. You understand that?
Yes, sir.
You also have the right to have a jury trial, as well as a minimum of 10 days notice to prepare for trial. Now, of course, you've had more than 10 days notice of these charges, but on this particular case, you have not had a jury trial. And yet I have been handed a document entitled Waiver of Defendant that says you want to give up the time, any additional time to prepare for trial, and you wish to give up the right to a jury trial. Did you sign that document?
Yes, sir.
And did you know you were giving up the right to a jury trial and that your case therefore would be heard by me today once you signed this document?
Yes, sir.
And is that what you still wish to do?
Yes, sir.
Mr. Keith, your signature is also on this document. Are you joining your client in these waivers?
Yes, Your Honor.
And Mr. Smith, your signature is on the document. Is that evidencing the state's joinder in the waiver of the right to a jury trial?
Yes, Your Honor.
All right, I'll accept those waivers and we will proceed. Mr. Hall, there are other rights and admonitions I need to discuss with you. Let me start by discussing the range of penalties that exist for this offense. A third-degree felony carries a range of penalties ranging from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the institutional division, and it carries the possibility as well that a fine could be imposed. If so, it would be in an amount not to exceed $10,000. Now, since we talked about there being enhancement paragraphs as well, if only one of the enhancement paragraphs was proven to be true, the range of penalties for a person convicted of a third-degree felony would increase to that of a second-degree felony, namely from not less than 2 years to not more than 20 years in the Texas Department of Criminal Justice, and carrying that same possibility of a fine, that is in an amount not to exceed $10,000. But we also mentioned that there are two enhancement paragraphs, and as they are alleged, if they are proven to be true, or if you admit them to be true and are convicted of the underlying offense, the range of penalties would be increased to that of what's called a habitual offense, or a habitual range of punishment, wherein the range runs from not less than 25 years to not more than 99 years or life in the Texas Department of Criminal Justice. Do you understand that those are the ranges of punishment that the indictment in this case carry?
Yes, sir.
Then let's go further, and I would tell you that I'm aware that a plea agreement exists in your case. I have looked at it. I do not have to follow that plea agreement, but I have to tell you if I'm going to follow it or not. Because if I decide not to follow the plea agreement for any reason, then you would be entitled to withdraw your plea of guilty in this case. However, and it would not be used against you that you had already pled guilty. It would just be taken back, and we'd start over in this case as if nothing had proceeded this far yet.
Yes, sir.
If, however, I do accept your plea agreement, then the law says you will be bound by the terms of the plea agreement, and you would not be able to get out of the terms of the plea agreement by changing your mind later or by filing an appeal. Ordinarily, there is a right to appeal, but your plea bargain agreement has a provision in it that says you're giving up the right to appeal. And if I follow your plea agreement, that provision means what it says, and you would not be able to appeal at all. Your plea agreement also says, as a part of this plea agreement, you're giving up the right to appeal in cause number 10,795. Do you understand that if I follow your plea agreement, you cannot appeal?
Yes, sir.
Now, I must ask you some other questions that I'm required by statute and court decisions to ask. So let me ask, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
San Angelo, Texas.
All right, sir. Next, I ask you, do you consider yourself presently to be mentally competent?
Yes, sir.
You know what's going on in these proceedings?
Yes, sir.
Have you been able to discuss these charges and the facts that either make up or surround the charges with your attorney and get his advice about what the law is with respect to the facts and this case? Have you been able to do those things?
Yes, sir.
Mr. Keith, do you believe your client is mentally competent?
I do, Your Honor.
All right. Mr. Hall, I usually ask it this time, and so I ask it again. Not again. I ask it again for me, but for the first time for you. The question is, are you satisfied with the legal representation you have received in these matters?
Yes, sir.
And do you understand that I asked that just to give you a chance to tell me if you were not satisfied?
Yes, sir.
And by giving you the chance to tell me now, while I could still get those issues resolved, if any existed, that necessarily means you're not likely to be successful if you wait until some later date to say your lawyer didn't do a good job. In other words, now is the time to tell me that if you think that exists. Do you understand?
Yes, sir.
And understanding that, are you still telling me you're satisfied with the legal representation you received in these matters?
Yes, sir.
Next, I ask you, has anybody forced you, tricked you, or threatened you, or in any way tried to make you enter a plea of guilty when you would not otherwise do so?
No, sir.
Has anybody promised to give you anything, some benefit, whether it's compensation with money or otherwise? Has anybody promised to give you anything just to get you to plead guilty?
No, sir.
Are you telling me then that you're pleading guilty to this particular charge because you are guilty of this particular charge, and that's the only reason you would plead guilty to such a charge?
Sir.
All right, those are all the questions I have at this moment. Mr. Smith, you may proceed.
Your Honor, the state offers for evidence a document marked as State's Exhibit 1. State's Exhibit 1 being this defendant's signed and sworn stipulation of evidence in this case.
No objection, Your Honor.
All right, Mr. Hull, let me talk to you about the stipulation and to mention some other rights that sort of fit right here. One of them is for me to tell you that the state is required to produce some evidence tending to show your guilt. And that's true even if you enter a plea of guilty. The state still has to produce some evidence tending to show your guilt. We call that's to protect your right to confront the witnesses against you. That means to have those witnesses who might testify against you be in open court, be sworn in, be testifying so you could see them and hear them while they testify. But this stipulation of evidence that's been offered says you're giving up that right, and you're telling the state as well as the court that the state doesn't have to bring their witnesses into court at all. Did you realize you were giving up that right, the right to confront the witnesses against you when you signed the stipulation?
Yes, sir.
Also, the stipulation says you're giving up your right to remain silent as well as your right to be free from self-incrimination. The right to be free from self-incrimination is the right to not be forced to give evidence against yourself. But instead, you are giving evidence against yourself because the stipulation of evidence is a judicial confession wherein you confess and admit that all of the material allegations in the indictment, including the enhancement paragraphs, that all of them are correct and true, that you committed the offense and have been convicted before of the offenses alleged in the indictment. Did you know that you were admitting all of those things when you signed the stipulation?
Yes, sir.
So the stipulation says there's going to be court costs there are court costs in the amount of $290. There's reimbursement fees owed in the sum of $675 and restitution owed in the sum of $90. Did you realize that paragraph was in the stipulation also.
Yes, sir.
All right. States Exhibit 1, the signed sworn stipulation of evidence is received as evidence in this cause.
State rest, Your Honor.
Defense rests, Your Honor.
State closes.
Close, Your Honor.
Mr. Hall, I'm going to go over the plea agreement with you as I understand it to make sure it's the same way you understand it. The plea agreement says to me that you're going to enter a plea of guilty to the charge as you have done. It says that's going to result in a 60-year sentence to the Texas Department of Criminal Justice. It says that you will be ordered to pay court costs totaling $290. You'll be ordered to pay restitution in the sum of $90 and also pay reimbursement fees totaling $675. The plea agreement says you will give up your right to appeal in this and cause number 10,795, as we have already discussed. It says that you will be given back time credits totaling 215 days. And since it does not specify anything to the contrary, it also means that this sentence will run concurrent with the sentence in cause number 10,795.
Yes, sir.
Now that's and concurrent means at the same time, not stacked, but at the same concurrent time.
It's 60. It ain't gonna be stacked, it's gonna be just 60 years.
That's
Is that right?
correct. That's right. That's
Yes,
what
sir.
it means.
Okay.
All right, that's my,
60s, is that right?
I'm sorry, I didn't hear that.
It ain't gonna be like, it ain't gonna be two 60s, is it? 60 and 60? It just be 160?
It will be two 60s, but they will run at the same time together.
Okay, okay,
It will not be stacked.
okay.
All right, sir.
Thank you.
Yes, sir. That's my understanding of the plea agreement. Is that the same as your understanding of the plea agreement?
Yes, sir. Yes, sir.
Mr. Keith, have I stated the plea agreement accurately as you understand it to exist?
You have, Your Honor.
Mr. Smith, have I stated the plea agreement accurately as you understand it to exist?
Yes, Your Honor.
All right, I announce that I will accept and follow the plea agreement. And so I state on the record in cause number 10,794, the state of Texas versus Tommy Ray Hull, that based upon Mr. Hull's plea of guilty and plea of true, and based upon the evidence stipulated to, I find that Mr. Hull is guilty of the offense of third-degree felony driving while intoxicated. Further, I find that the enhancement paragraphs alleged in that indictment are true. With those pronouncements being made, Mr. Hull, do you know of any legal reason why a sentence should not be imposed at this time?
No, sir.
Then following your plea agreement, as I announced I would do, I hereby sentence you to serve 60 years confinement in the Texas Department of Criminal Justice, the Institutional Division. I order you to pay court costs in the sum of $290, restitution in the sum of $90, and reimbursement fees in the sum of $675. I also announce that you will be credited with time served for 215 days, and that this sentence will run concurrent with, that is at the same time as the sentence in cause number 10,795. Do you have any questions, Mr. Hull?
No, sir.
Then those will be the orders of the court. Your thumbprint will be required on this judgment, and someone will bring that to you shortly at the jail to get your, I said fingerprint, but your thumbprint. And we will be in recess, which means you may, thank you, sir. You may be excused from that room.
Would y'all put on here that, oh, y'all don't have to, oh, so what does TPC get both of them? Oh, but on paperwork, it is like the highest paperwork will have, right?
Gonna get her on?
I help her fill it out and then I'll get it on.
Is she doing a request? She's just doing the acknowledgement of her rank.
Oh, okay. So she just got to get on.
Uh-huh.
You want to leave it on this one?
Yeah, let's just do it. Do we have anything else? Trey, is there anything else?
I think all my stuff is handled for the day.
That's what I show.
Okay.
And we're
So
going to do another, finish up that other arraignment. But you started to say something.
I'll just, I'm gonna wait and see if I can hijack Terry to join me for some lunch, I think.
Okay. We won't be much longer.
All right.
All right, I'm back on the record in cause number. Ms. Mayfield, can you unmute? In the upper right-hand corner, move your cursor to the upper right-hand corner and click on unmute. There.
Can you hear me now?
Yes, ma'am. And that means you have a Verizon phone. No, that's a joke. Sorry. I call cause number 10,859 for the case style, the state of Texas versus Monica Lynn Mayfield. Ms. Mayfield, do you have the acknowledgement of arraignment form?
Yes,
Would
sir.
you hold it up right in front of the camera on the laptop so I might see the signature? Thank you, ma'am. Is that in fact your signature?
Yes, sir.
Do you have any questions about that acknowledgement of arraignment?
No, sir.
Or any questions about the proceeding you've been through, the arraignment you've had this morning?
No, sir, I don't.
All right, then that concludes your arraignment. You should leave that document there on the table. And you will be, a deputy will be by to pick it up in just a moment. You may, you will be excused until next month. You will get a notice and your bondsman will get a notice, but I can tell you now it's scheduled to be March 4 at 1:30 in the afternoon. If your attorney, if you have employed your attorney by that date, we will send the notice to your attorney, and you and your attorney will then, of course, need to be in communication with one another. All right, that concludes our arraignment this morning. Thank you. You may be excused.
Thank you. I appreciate your time.
Yes, ma'am.
Thank you.
All right. We're through. Mr. Smith and I and Mr. Oliver and Mr. Hanshew are through until 1:30. And I will advise Mr. Hanshew that if he wants to run the other way, he may do so. Otherwise, Mr. Keith is looking for him. All right. See y'all.
See you in a bit.
Thank you. I hope it's more than a minute. Randy,